All right, welcome back. So this is the capsule on the beginning of Chapter 6, which is procedural fairness. You'll recall we talked about procedural fairness quite a bit. We said first, I actually repeated it, I think, just a few minutes ago, if you watched the video just before this one, is to the Baker case. So you'll recall, pursuant to Baker, there's no actual clear standard of review that applies to a procedural fairness issue. It depends on the importance of the issue, of the decision made to the person, right? So if you're taking away a lot of their rights, then there will be lots of procedural fairness, and the court will be also less deferential in reviewing that. So, right, same thing as the law, right? If you put someone in jail, that's a lot of freedom you take away. You put them in a cage, right? That's their freedom of movement, their freedom to do whatever they want, to get a job, right? You're taking away lots of their rights. Therefore, that is done with a lot of due process, right? They go before a court, they get a free lawyer, they get to cross-examine people, all sorts of things, right? For example, in a criminal law, you get a free lawyer more often than in civil law because they're taking away more than your money, they're taking away your freedom. Same thing in administrative law. You'll look at the seriousness of the thing, right? A driver's license is opposed to sending you back to some other country to die. The nature of the procedural fairness obligations will vary on that. So if it's a big decision, right, you'll have lots of procedural fairness. You'll have get to cross-examine witnesses, get to show evidence, all that. And the court will be less deferential, which kind of makes sense, right? Because then not only do you want these to apply, you want them to be checked, right? If the court, upon judicial review, were to be fully deferent to it, right, it wouldn't work, right? If the court couldn't look into what actually happened, because it's reasonableness and it has to stay away, then you'd have all the obligations, but no way to make sure that they've actually been met. So, what does procedural fairness mean? Right? Essentially, it means two things, right? At least to me. So first, it means that you have an opportunity to be heard. And both of these have a lot of permutations. But first, there's an aspect to it which is, right? And both of these are really about justice. They're really about the thing being fair. That's why it's called procedural fairness. Right? This idea that the law isn't just about the stuff written on a piece of paper, it's about actually applying that to achieve justice, which is more subjective and hard to grasp, right? First, you have an opportunity to be heard. That's why you're allowed to, right, do all the things that we do in the court system. You're allowed to know what they are saying that you did, whether it's civil or criminal. So you have to know the case against you, and you have to know it ahead of time to be able to prepare. Then you have to have the ability to put down documents that say this is why it's wrong, witnesses that say this is why it's wrong. Then you have the opportunity to look at, right, the witnesses of the other side and ask them tough questions to see whether or not they are lying. And so it kind of looks like you did it, but it's because they're lying. And so you get the opportunity to cross-examine them, right? The right to be represented by a lawyer, which will do that better than you, which will be able to say, this is the law, and this is why it's not legit. And you might not know the law, because you're a normal person, right? So you have the right to hire a lawyer to translate it for you. All of that is about being heard. It's about being able to tell the tribunal, the decision maker, what you think about it, and often why you think it is wrong, right, what you are being charged or, right, reproached with. Then the other aspect is what happens on the other side of that, which is the decision maker. That person will be expected to hear you. They'll be expected to listen. They'll be expected to actually consider what you said. They'll be expected to decide based on that, not based on what they think, based on their personal or political preferences, and be free from bias, right, from taking bribes or whatever it is. So two aspects, right? You as a litigant or as a claimant, a person, and then the nature of, right, the person, the obligations of the person making the decision on that. All that is considered to be, right, inherent. It's considered that, right, it's just not fair. Whether it's because God said it, right, or because human beings are inherently intelligent, right, there's a sense that naturally when some entity, which often is just made up, right, the government's made up, it's not, you don't find it in the woods, right, it's something we made up. And if that thing is going to take stuff away from you, we want it to be fair, just naturally, right, even though there's no specific obligation for that to happen. And that's what we call natural justice. It's what we call procedural fairness. And that is pursuant to the rule of law, right, which is the idea that you have to be governed by rules and they have to be clear. And a corollary of that is that the decision has to be fair and has to be made in a way that is fair. That arises by virtue of the Constitution, period. So Constitution applies to administrative law. We said that a lot of times. You should know why, right? Therefore, it imposes certain obligations. These include obligations by virtue of the preamble and all sorts of things, right? Rule of law, unwritten principles, all that, right? Essentially creates an obligation for the decision to be fair, to respect procedural fairness in the absence of an obligation. So even if the government, right, creates a body specifically for it not to be a court, for it to be cheaper, because one of the problems with everything we just said is that it costs a lot of money, right, for you to be able to go to court and do all these wonderful things, right, put down your evidence, cross-examine witnesses, all that, right, for you to be able to do that costs money, and that's not necessarily good. Because if you have no money, you get none at all, right? So you have all these wonderful obligations in theory, but if you've got no money, you get none. And that's the worst possible scenario than if everyone had fewer. So government might see that, might create an administrative body with simpler rules to make it fairer to everyone. It doesn't mean that there's no obligations, that the government can do whatever it wants. It can do some stuff. It can limit these obligations somewhat, less than a court, for the valid reasons we just mentioned, but, right, they always apply. So you always have some procedural fairness by virtue of the Constitution. So the Constitution says you're protected. So if the government tries to make really important decisions, or tries to make them in a way that's completely, right, prejudicial to your ability to say what you think, it's not going to be allowed. It's going to be allowed somewhat, but not, right, entirely, because these obligations apply regardless. They apply because the Constitution is senior, and it applies regardless of legislative intent, right? At least the bare minimum applies regardless of whether the government specifically intended that. The government could have intended for you not to be heard. Doesn't matter, right? And it doesn't matter that it's not specifically provided for. So even if the statute, of course, doesn't say you have a right to talk, you have a right to give documents, you'll still have it because it comes from the Constitution, even in the absence of a statutory provision. There's a provision that's good, it'll orient you, but that doesn't prevent you from saying it's not sufficient, and doesn't prevent you either, if there's none in the statute, from saying there should be. Okay. 269, different way to put what I said. You have an opportunity not just to be heard, but to potentially influence the decision. So to be heard, right, to make yourself heard by saying stuff, and to be heard, right, for the person to actually listen to what you're trying to be heard about. Okay. Then there's an issue as to the nature of the body, which no longer applies. That's the bottom line, right? Essentially, at first, right, before the law developed, there was something called a quasi-judicial body, where you would look at whether something looks like a court. And if it looked like a court, it would have obligations that look like a court, which kind of makes sense. It doesn't work that way anymore, so if the government creates something that doesn't look like a court, it doesn't matter. What matters is what we said. What matters is the significance of the decision being made, which then influences the extent and nature of the procedural fairness protections that apply, again, inherently by virtue of the Constitution. And then, right, also the deference that's owed by court in checking whether that actually happened. Doesn't matter. It kind of still does indirectly in the sense that usually, and that's why it might confuse you, right, and if it does, forget what I said, but the government will often know its obligations. It's going to know that it has an obligation for there to be procedural fairness that's reliant on the importance of the decision, because it knows the Constitution, right? Doesn't want to be struck down, usually, so when it designs an act, right, to create, say, an administrative decision maker, it will design it in a way that respects its obligations. For that reason, oftentimes, by accident, you'll have decision makers that make big decisions look a lot like courts, because that's what the Constitution says. It says you get lots of procedural fairness if it's a big decision, therefore it looks like a court, because you have obligations that are similar in extent and stringency to those you'd find in a court. Therefore, by default, if you look at stuff today, if it looks like a court, it's likely to have more procedural fairness obligations, right? But that's taking it backward. It's not because it looks like a court that there's lots of procedural fairness obligations. It's the other way around. It's because it makes big decisions that there are therefore lots of procedural fairness protections, and therefore it looks like a court because it has to. If it doesn't, it's struck down. So the nature of the entity no longer matters. By accident, it might look like a court, but it's not the criterion. The criterion's the other way around. It's how significant the decision is. I won't repeat it again. And you have examples of that, right? First witnesses. That's the first kind of level of that. And you don't always have that, right? You don't always have a right to have witnesses heard, including yourself, right? So they might say, it's only you. It's not your 5 neighbors, because that would be expensive. It would take 5 days, and it wouldn't be particularly useful. They can say it's just you. Or they can say you don't talk at all. They can say you'll express yourself in writing. And that's not as good, because then you don't know, right, what face the judge is making. You don't know how to orient what you're saying with how they seem to be going, how they seem to be thinking, right? You don't have an opportunity to respond to their questions, right? Still, depending on the importance of the decision, if it's less important, they might force you to express yourself in writing. There's nothing illegal with that. Then same thing with, right, cross-examining witnesses. Usually when there will be witnesses, they'll be cross-examined. And then other things, right? How long you get, how much law you get to plead. All of these are restrictions. But usually the first level is, right, and you've got these examples. I'm getting ahead of myself there, but page 281, you've got some examples there. It's just a law. It doesn't really, it's not a bunch of things you have to have. It's just an example. That's an example of the government trying to do something illegal. So I just said, right, usually government doesn't want their new thing to get struck down, so they'll design it properly. They'll look at the importance of the decision that the prospective decision maker will make. And they'll say, right, these are the procedural fairness protections that are likely to apply by virtue of the Constitution. We'll make sure they're respected. This is what the government did there, right? I think it's in Quebec. I think it's about cars. Doesn't really matter, right? Finally something about cars, eh? So it provides for obligations. The statute does. If it didn't, the Constitution would, right? But statute does. First, inform the citizen of the case to be met. This usually is first level, right? I think the example is useful because it's actually the things in order that you get. First, know what they're saying you did. That's the first level. The biggest denial of procedural fairness is, right, they're trying you, essentially, or making a decision based on something they say you did. You don't even know what it is, right? Before you get the opportunity to say it's wrong, you have to know what it is that you have to respond to. That's the first level. Second level, inform the citizen of the substance of the complaint, right? So what does the government want to do? Why? 3. Give the citizen the opportunity to present observations. Again, writing or speaking, depending on how serious it is, and documents to complete the file. 4th level, oftentimes, right? You might say you might be able to produce documentary evidence in addition to rebutting the case. So you might say verbally, right? Government, you're wrong. I do meet the criteria, right? I'm not blind. Another level is you also get to submit documents. You get to say, right, this is an incomplete record. You've got some documents there, and I'm saying they're wrong, but you're not believing me because it looks like they're right. But if I give you these other documents, it will complete the picture, so complete the file. And then you get into the more hardcore stuff, right? 5th, 6th, and 7th levels, right? Whether you get to have witnesses on top of yourself, whether you get to cross-examine witnesses, whether you get access to a lawyer, etc. And the review of the court will be driven by, and the examples are reiterated at page 282. Some of them 281, some of them 282, some of them I made up. The review of a court, as I said, I just want to reiterate it, will be driven in deference by the importance of the decision. And one of the aspects of that is whether there's an quote-unquote alternative remedy. So if there's no statutory right of appeal, namely some other tribunal, car appeal tribunal you can go to, then the court will be less deferential because it's the final decision maker. In other words, it's the only place you can go and say it's not fair. And therefore, the court's going to be less deferential in actually making sure that it was fair, that the obligations that apply do apply. Then there's a mention, page 282 of the Charter. We said all that applies inherently by virtue of rule of law on written principles. Now it also applies by virtue of the Charter. Because the Charter, Section 7, protects your right to, and we looked at that before, right? Protects your right to life, liberty, and security of the person, and your right not to be deprived thereof except in accordance with the principles of fundamental justice. We looked at all that. We looked at what the principles of fundamental justice are, right? What the right to life mean. Essentially, oftentimes an administrative decision maker, not always, but often, will make a decision that affects your right to life or liberty or security of the person. So, life meaning life, right? So, send you back some other country, you'll die, or you're more likely to die. That's your right to life. Liberty is liberty, right? They prevent you from doing something you'd otherwise want to do. Doesn't mean jail, right? Could be something else. And security of the person. Security of the person is not to be, right, at risk of things that are painful, for example. All of these will often be affected by administrative decisions, and therefore there will be obligations there as well. So often more stringent obligations that will come from Section 7 as well, and the principles of fundamental justice. And we will stop there for this week and get back to Chapter 6 next week.